A lot of lawyers in Missouri seem to settle their workers' compensation cases very quickly. Why is it important to go to hearing?
It holds the insurance companies accountable. It shows them that we're willing to go to the mat for our clients no matter what the issue is. In Missouri, you're entitled to 3 main benefits, and the work comp insurance company is going to fight you on all 3. We see it all the time.
What are the 3 benefits?
3 benefits. The first one would be temporary total disability. That is 2/3 of your average weekly wage while a doctor has you off work. The second and the main benefit is authorized medical care. That's the most important one, and that's the one we have to fight hardest for. When you go see a work comp physician, they're going to tell you that there's nothing wrong with you, or they're going to release you from treatment too early. At that point, we immediately need to get you in for an independent medical evaluation with one of our physicians who will make an opinion as to whether or not they think you need more care. That's when the fight begins as to whether or not more care will be authorized. And that's why it's so important, because that is the main benefit, to push those issues to trial when those denials come in, because I guarantee they will come in.
All right, so 2/3 of your wages while you're off, 100% of your authorized medical bills, and then a lump sum payment for permanent or partial disability.
Correct, that's the third benefit. Everyone thinks in Missouri that the permanent partial disability settlement is the main benefit. It's not. The goal is to get you the care that you need. We'll put a little bit of money in your pocket at the end of this, but also to get you back working as if this injury never happened. We need to hold these insurance companies accountable for the medical care that you are entitled to per the Missouri Workers' Compensation Statute.
All right, I want to introduce everyone to you. This is Jason Hackett. He is a trial lawyer at Cantor Injury Law. He had a trial yesterday on the issues that we're describing. He obviously knows his stuff because he's been with me for how many years now?
Almost 5.
Almost 5 years. So he is an incredible young lawyer, and he really knows the ins and outs of workers' compensation. And the proof is in the pudding, because yesterday he had a hearing where the employer was withholding like $1,000 MRI, why is that so important?
It's important, like I said earlier, to take the insurance company to the mat on these issues. They're going to get away with denials if you don't have proper aggressive representation for all these 3 benefits. You have to milk the insurance company for these 3 benefits. The state of Missouri says that you are entitled, as an employee in Missouri, you are entitled to these benefits. Regardless of that statute, the insurance company is going to try to deny you of those benefits.
And when they deny it, so an MRI could lead to a diagnosis and get a surgery. But what the employer tries to do is bury their head in the sand and say, we don't owe it. So Jason took him to task yesterday, and he in front of a judge, he put witnesses on. I'm really proud of him because he caught an employer lying about what's called notice. Tell him what notice is.
In Missouri, you have to put your employer or the work comp insurer on proper notice that you had been injured at work. In this specific case, there was an allegation from the defense that there was no proper notice given. We were able to, through cross-examination, kind of get that out of the employer that they did know about this injury.
So that's all excellent work. And you understand that this is an interim hearing. It's not the final hearing. Explain what that is.
Sure. So throughout any workers' compensation claim, we may go to a hearing over a number of issues. One may be past owed temporary total disability that the insurance company refused to pay. One may be something as simple as the insurance company being cheap and refusing to authorize an MRI for potential injuries. And again, like Mark said, the purpose of that from the insurance company is they want to save a buck. That's what they care about in these cases. They don't care about you getting back to work. They don't care about the bills that stack up, and they don't care about the lump sum that they provide you. All they want to do is save a buck.
And did the claimant, the injured worker, have to pay us anything extra to have that hearing?
Nope. We do that because we think it's important to hold these insurance companies accountable.
So the way we charge a fee is on the lump sum payment at the end of the case, or if we have to fight to get you medical. So a lot of lawyers, if they settle this case, you're never getting that medical. And listen, you got to talk to the lawyer, you got to have boots on the ground. Sometimes you do settle cases, but we prefer to hold the insurance company to task and make them pay all the money that they owe. You can count on Cantor to do that. We never charge a fee unless we win. 314-628-9999 or visit cantorinjurylaw.com. When you come to us, you get us. We're not a national firm. We're not advertising nationally. We're boots on the ground. We only handle personal injury cases like auto accidents, truck accidents, motorcycle collisions, workers' compensation. We are the guys in St. Louis to help you. And we have lawyers like Jason Hackett, incredible young lawyer. I'm really proud of him. I keep saying it because it's true, because most lawyers never try a case in their lifetime. And this guy's out there trying cases. So congratulations, Jason.
Thank you, Mark.
Job well done. We're going to put this on the air and we're going to get more business because of it, because we're very good at what we do. Thanks for watching.